we just go ahead and start. And which of our three panelists is going to start from the beginning? Is it going to be you, Bill?
Yes, Tasha had asked me to start. And when I
Okay.
looked at Laury Lucien's PowerPoint, which I only saw recently, she has so many more slides than I do, and they're so much more interesting. So thank you for including me here. And my section, I'm going to actually try to keep it shorter than our allotted time, so that Laury can do her stuff, which was very impressive when I read her PowerPoint. My PowerPoint doesn't have as many pictures, but you do see it up on the screen, and I'm letting somebody control screen. So if I say next slide, that'll move us on. I do want to thank IPSJ again for inviting me, and very impressed with the award that was just given, because I got the same award a few years ago. And I guess there's a few of us who have this legacy history of being with Lateef from the beginning. And it's really exciting to know and to do. And of course, people who've come in later are more stellar than I am. We have judges. I'm just a senior litigation trademark lawyer at Pryor Cashman. But it's impressive to see so many people on the panels here and on the group. I also want to give a shout out to Camilla Holder from my firm, who has joined us today. And she is on the diversity committee at our firm. And I've worked with her on a number of matters, and she is a regular assisting associate to me on some very complex trademark matters. I'm really glad to have her. So this topic today is the cannabis and the law, a look at trademark law and social justice implications. The first thing that jumped out at me when I was assigned this, and I will say cannabis law is not my choice. I like going after some ethics issues in prior sessions, as you know. And I previously did a PowerPoint on disparaging trademarks, which I disapproved, but the Supreme Court overruled me and opened up the floodgates. But that's a whole nother lecture. So, but cannabis is an up and coming area, and it's a very timely subject. So we're going to go through it right here in terms of what the Trademark Office has been able to do right now. So let's go to the next slide. And that's just who I am, which you can have 10 seconds to read, because there's a bio out there somewhere in the published materials. And next slide. This is the usual disclaimer that we've heard from everybody. I hear slightly different versions of this. I say this is not to be taken as legal advice, obviously, and is not the views of my firm or the IPSJ or Howard Law School necessarily, but I do say it is my views if I have anything in here that's opinion. So I've heard somebody say it's not my views. I think that was Ian Balance said not my view either. Don't quote it back to me. I don't go that far. Next slide, please. So now here's where we start out. The background on registrability, and I apologize that this slide has a lot of gray matter in it. You can't always present all this with just one sentence bullet points. The basic issue was that in 1970, the Controlled Substances Act, CSA, listed marijuana as a class 1 substance, which made it illegal to produce it, possess it, use it, sell it. This created the problem that since the trademark law the Lanham Act requires use in commerce, if you're going to get a registration, you can file an intent to use, but you don't get a registration until you actually use it in commerce. So if you can never legally use it, by definition, you have no business filing an intent to use it. And when we say legally, it means legally in all manners, not just under state law, but federal and state. And that's why the trend, which is discussed here in this slide, about how we are seeing more and more states legalize it or decriminalize marijuana, is not solving the problem in the Trademark Office, at least until what we're going to discuss after this, about 2018. So you have this trend towards legalizing, but it's still a designated controlled substance. So you can't use it legally. Now, there is a new case floating around, which Tasha pointed out to me just recently. I hadn't seen it actually. It was written up on February 28 in Law 360. You can take a look at it. There's an amicus brief on it, an ITU application for I'm looking to the side here because I have it here on my papers. And there was an application for an ITU for marijuana based product, and the PTO said, no, we don't do those because you'll never be able to use it. And the amicus brief argues why that's bad policy. There's some things I probably disagree with in the amicus brief, not on policy grounds, but just on the issue of that the FDA also has to approve some things. But it's not necessarily true that because the FDA has to approve it, it's the same illegality as the CSA, which makes it like contraband. You could never have it legal in the United States under federal law. Now, until that's changed, and there is a move afoot to change that, by the way, which is mentioned in my paper here. And if you look at footnote 1, there is a reference here to the source Schumer state sponsors letter on Cannabis Administration Opportunity Act. So this CAOA Act is something that Senator Schumer and 2 other sponsors are working on to really try to, on a federal national basis, revise the marijuana laws nationally and I believe also affect what you see in the CSA. Let's go to the next slide. So because it's different in different states, you have inconsistencies, and the inconsistencies state to state present a lot of conflicts. I thought these up. I think I thought these up. I don't think I got these from somebody else, although I've seen them in different places. Obviously, if you're in a state, which on the previous slide, I think it was, but there's 4 states that still have it as illegal out of the 50. If you're in that state, you have personal criminal exposure. In the other states where they've reduced the penalties, you may still have some penalty. Obviously, law enforcement priorities vary state to state, depending on what the state is trying to accomplish, and it seems to be a state choice. The federal government has sort of, depending on who's in the White House, but the federal government has taken different views on how strongly the Justice Department will enforce the CSA as a federal violation dealing with marijuana. Back to my list here, states' legislative freedom to enact laws for its citizens. Again, there's a concept that each state has its elected officials and its legislature, and policy-wise, they should be doing what they think their citizens want to do. Public health and safety, very important. Marijuana starts to get approached, for example, alcohol. You know, we had a prohibition on alcohol even before I was born. And so that's an issue that floats around when you have a prohibition on something, but then you lighten it up. What do you do with public health and safety? Does that make it more likely that people will drive stoned? That's very dangerous. So how do you control that? And then economic development is you legalize it, you tax it. I know I'm in New York, and that's where the taxing, they just legalized it, and they're still trying to get it off the ground. They're not as fast as some of the other states, but they're going to bring in tax monies on this, the way they tax alcohol and tax tobacco. Next slide. So this is the point I was making at the beginning, that unlike the copyright and patent law, in order to obtain a federal registration under the Lanham Act trademark law, you do have to show use in commerce. And there was a new legislation, as you see here, passed called the Agriculture Improvement Act of 2018. And that was effective as of December 20, 2018. Prior to that time, marijuana was still deemed to be a controlled substance, and therefore you couldn't use it federally, and therefore you couldn't get a registration for it. That's what this slide is telling us. Could not lawfully use it in commerce. Next slide. So the TMEP, those of you who practice trademarks regularly, as I do, Trademark Manual of Examining Procedure, TMEP Section 907, makes clear what is already part of the law, that you must use the goods or the services in commerce. And the USPTO, in appropriate cases, this is guidelines beyond the statute. USPTO may make appropriate inquiry as to compliance with federal laws when they get an application to see for the sole purpose of determining the lawfulness of the commerce that's recited in the application, and that is even in the intent to use category. This has been in effect for many years and expressly refers to the CSA regardless of state law, meaning even if it's legal in a state, marijuana, because of its psychoactive component, THC, remained a Controlled 1 substance. I think this section of TMEP, which when I looked at it last, has not been changed, even though we're about to see the 2018 amendment to the agriculture law actually made a substantive change and took a piece of marijuana out of this prohibition. Next slide, please. So in 2019, and it was actually in May of 2019, that, and it's the link is annexed here to the end of the PowerPoint, the PTO recognized that the statute had made a new definition, and it said if you define hemp, or the statute defined hemp, which is certain parts of the plant having less than 0.3% THC, and they mean that by dry weight. I don't know whether it's liquid weight or dry weight. I see all kinds of products in liquid now too, but not to get too complicated. Less than 0.3 THC, which is the psychoactive component, that's going to be hemp, and that's going to be removed from the definition of marijuana, which therefore removes it from the CSA. And thus, those kinds of products, if they will expressly indicate less than 0.3% THC, can now actually be the subject, products and services can be the subject of lawful use in commerce. That is a huge change and shows that we're moving towards allowing this somewhat the way alcohol prohibition fell decades ago. The exam guide is detailed, tells you how this will be administered. It's more detailed than we can cover in this session, but we'll go to the next slide, which tells you the basic issue. So here's the definition I just mentioned, very complicated terms. I'm not going to try to pronounce the chemical names, although I have a technical background, which all the judges said you should have if you're going to be in patent law, which I do that too. But I won't try to pronounce it. These changes include removing hemp from the CSA's definition of marijuana, which means that the cannabis plant and derivatives that have less than 0.3% THC are no longer controlled substances, therefore they can be used. And I can tell you, just from personal experience, not with marijuana, but with a patent application that had a suggestion of marijuana several years ago, where the word pot was part of the composite mark. The examiner heard pot and thought, well, a pot something might be marijuana, and it was an ITU, and said, I'm going to deny this because, or I'm going to not approve this because you have to tell me whether it's going to be marijuana. And I believe I argued back and I said, no, you should allow this because as an ITU, we don't have to tell you at this point whether it's going to be marijuana. I was thinking ahead for my client, maybe marijuana will be legal at some point. But the examiner stood by their grounds and we didn't continue with the application because there was too many uncertainties. But it just shows you how vigilant they were. And I also think I'm right that until you make use of it, maybe the use would turn out not to be marijuana. But of course, if I committed to that, then we'd be stuck with that. So that was the issue. Next slide, please. So this is the new examination procedure, and it has this cutoff date. If you filed an application after this effective date of the Agriculture Farm to a 2018 Farm Bill Amendment, after December 20, 2018, and you can define your product or service as having less than 3% of THC, then it would no longer violate federal law. By not violating federal law, you can make use in commerce, meaning interstate and overseas commerce with the United States, and the goods would be legal. Cannabis with more than the 3%, second paragraph of this slide, is still going to be a problem. And as I said, except for the one case that is the T case, which an amicus brief was filed on recently, that is still the law in the PTO. So, but if you can meet this restriction, last paragraph, then yes, you could file for this. It's going to be called hemp, and you can get a registration, whether it's an ITU, and then you make use of it. Obviously, if you make use, make sure the client's use is less than the 0.3 THC. Next slide, please. So this is part of the remaining issue that even if something becomes federally lawful, which the 0.3 is, if it's going to be a food or dietary supplement for ingestion, it may require FDA approval. And the examination guide makes that point. So the statement here is that, therefore, registration for marks for foods, beverages, dietary supplements, or pet treats that have CBD will be refused, even if they derive from hemp, because they have the correct percentage, but they have to pass the FDA. Now, I'm thinking about that, and what use does the does marijuana or hemp, I guess they use that term. What use does the now lawful hemp have other than something you can ingest like this? Query, if it's in a smokable product, is that different? I don't think so. I think if it gets into the human body, the FDA has jurisdiction, but that's beyond my area of expertise. Next slide, please. So as I said before, this amendment, anything that suggested marijuana in the application, usually in either the description of goods or even in the brand. As I said, somebody came up with a brand that had the word pot something in it, but a composite, not pot lunch, but pot was mixed in as a composite word. I always tell clients, you get better trademarks if you don't make it two words. A composite or a unitary mark is much harder to be disallowed because it's not something that's in the dictionary. So you say, pot lunch, and that's two words, and each word has a specific descriptive meaning. If you said pot lunch, one word, maybe that's a better mark. Nice example of that, which I use with clients all the time, is Fitbit. Okay, that's a registered trademark. So fit means you stay in shape, and bit is a unit of computer memory. So that was a clever combination unitary mark. Anyway, as I said, the old rule was if they saw pot anything or marijuana or something or reef anything, they'd get your rejection. This amendment now gives you that room that if the product's going to be not more than 0.3%, you can get it applied for and approved, and that has actually happened. When I went to look for that for this lecture, I was a little surprised to find one of these Chinese applications. And when I say these Chinese, I'm not meaning to target that country per se, but the record of filings in the USPTO is showing that there are a large number of Chinese applications for what I call nonsense marks. And this has been a pet peeve of mine now for several years. It's been in my prior lectures too, and I was here able to include it because sure enough, one of these is for a 0.3% or less product. If we go to the next slide, you'll see what I'm talking about. Somebody applies for KHM, I can't even say it, KHM-SYOG. So that's not pronounceable in English. It's just a random jumble of English letters. And who's applying for this? Well, forget first who's applying. Notice the applicant has correctly, specifically pointed into the description of goods that it'll be not more than 0.3% THC. That's what they had to do to make this legit for a hemp product. And I think the next slide has more information about this application. Yes. So it got registered, and the registrant is an individual in China, and his hometown is in a town in China, and he gets a registration number, and the attorney of record is somebody named Weibo Zhang. Now, I'm not picking out a particular attorney. This came up by my random search for trademarks that had been allowed for hemp under this new exam guide. But it does raise a more serious issue, which I would like to touch on because we have 44 people watching. I hope some of them are in a position to fix the problem, which is that it has been reported, and in my prior lectures and in the media, that the Chinese government is paying a bounty to any Chinese citizen who can obtain a U.S. registration. So the bounty not in Chinese money, but in US dollar money, exceeds the cost of the application fee. So you get a net profit. So that's a huge financial incentive for every citizen of China. And you know how many million people there are there. And some of them are very technically savvy to make applications for things that they claim to have in use with a mark that won't be rejected because it's confusingly similar to something or descriptive in English. And they get it registered, and they get their bounty paid, and they make money. And this has overwhelmed the PTO examining group, and it's still going on today. The PTO saw it happening and thought they could stem the tide by putting in a requirement. If you're a foreign applicant, not necessarily China, you need to employ a US licensed attorney because they have ethical obligations to the Office of Enrollment and Discipline to make sure that everything in the application is true, that there is a real use in commerce. On the other hand, the use of the internet, and you can post up something for sale on the internet, makes it very easy to create a specimen that may not actually be for sale or be for use, but you could post it up. So there's also this strong trend of fraudulent specimens. Let's go to the next slide. So this is the other issue I've been discussing. Large-scale filings are being made of allegedly use-based PTO applications for nonsense word marks like this one that I can't pronounce, and nobody can pronounce it. And that's because if they use nonsense letters, they will not run afoul most of the time of a conflict with an existing US application or trademark. And they don't want to run afoul because they want to get the registration and they want to get their bounty paid by the Chinese government. But they had to use US attorneys. So at the bottom here, you take a look at this application, you see it was filed by an attorney named Weibo Zhang. So the next step whenever you see one of these Chinese applications is you go to TESS, T-E-S-S, which is a public-based search system at uspto.gov, and you could put in that attorney's name. How many filings did that attorney make? And if you want to really be interested, you say, and let's restrict that search to be the owner has to be in China. So if you go to the next slide, I ran that search, and it's a little hard to see, but if you look in the where it says refined search in the middle of this slide, the search was for that attorney's name, AT attorney, and OW, the owner has to be in China. And I came up with 18,151 records. Now I haven't read all of them, but the first 100, if you look at the first 100, and I couldn't even put the first 100 on a slide, look at the first 12 here on this slide. How many of these are nonsense combinations of English letters that are not producible? They fall right into this category I just discussed, that Chinese applicants are making applications for nonsense letters to get registrations to earn a bounty. And that's what this appears to be, and that's what this attorney appears to be doing. So this is, you can do this, by the way, randomly, as more randomly than I did. I did it for hemp, but if you just put in class 28 for toys, you know, or any class you like, and just take the first 100 hits, you'll start to see some of these nonsense words. And if you click on one and see who the attorney is, go search that attorney. I did check, by the way, that attorney is a licensed attorney in the US. How he's been reviewing, or she's been reviewing 18,000 records of applications to make sure that they're all bona fide, I can't answer. Next slide, please. So this is the end of my rant on this. My rant is I don't like these because they interfere with a lot of genuine and legitimate things that the register is supposed to be there for. Now, the PTO is working on this. They just recently issued a Federal Register request for a comment on a new sanctions procedure that may help. But here's what I see as the problems. This is my opinion. All these nonsense word applications are causing the problem that the PTO application volumes have hugely increased. And those statistics are shown. You go to uspto.gov, you can see the statistics on pendency, how long it takes now to get a first action. It's all there, okay? It's overwhelming the trademark examination group, which is why pendency is now up to 6 months instead of 3 months that it used to be, as you see in the third bullet. Examinations of these words slows down this review, the first review for a first office action, to 6 months, which has a very adverse impact. The whole point of ITU, when it was invented, and not invented, but enacted, was so that if a company was going to make a huge investment in a new brand, and particularly a brand that had a lot of capital intensive investment, like a new new vehicle that would have a brand, you would want to know years in advance, should you be building a plant to make this vehicle under this brand, because you need to get it approved. And as an ITU, you need to at least get a notice of allowance after review to know that the PTO has no problem with it and they approve for publication, and nobody opposed it, so you get a notice of allowance. Now you can go ahead with your development. But now that's going to be delayed, and it is delayed. And clients are saying to me, what? I can't get clearance on this in 3 months? I'm going to have to wait 6 months, and even then there could be an office action. My last bullet is that the principal register is now cluttered with these nonsense registrations. This mark we just looked at is registered. Is that a problem, cluttering the register? I think it is, because now and then, even with funny, crazy words, they might accidentally, on purpose, fall on a mark which actually is pronounceable and can be used. And again, personal experience, I have a client who has a mark, confidential so far. It's already registered, but what I'm upset about is that apparently that mark is it came up as one of these nonsense words for some other completely unrelated product. And I suspect that the proof of use for that from China, that proof of use is going to be suspect. So now and then, even one of these nonsense words will create a 2D, meaning a too similar word that could cause likelihood of confusion, which would cause a genuine mark to be rejected. Now, my client's mark's already registered, and this one is for a different class, so it may get registered, but it's diluting nevertheless. Next slide. So now we come back to the real topic here, and thank you for indulging my rant. The impact of the trending marijuana legalization and decriminalization. We've seen these state law amendments. Many states are allowing it in one way, shape, or form, or decriminalizing. The CSA has removed it if you don't exceed 0.3%. That's hemp. And now Senator Schumer's legislation, which is pending with 2 sponsors, looks to even more broadly, federally, expand the legalities for and possibly correct prior convictions for marijuana violations of federal law. So as I say at the bottom here, it's not surprising, therefore, that the trademark law, U.S. trademark law, is moving in that direction, and the 2018 Farm Amendments has certainly done so, allowing you to register 0.3% THC or less products. And for that, I would say that's perfectly fine. Please do that. Please pick a brand that you've searched and that has some meaning, that makes for a good brand, and that you would like an ITU because you're going to come out with it in 6 months or later. That's all good. So to that extent, we've really improved the opportunities now for people to make those applications. Next slide, please. Because this is the IIPSJ, Institute for Intellectual Property and Social Justice, I always like to include some social justice in here. And I found that there was a group called the MCBA, Minority Cannabis Business Association. They say they're the first national trade association dedicated to serving the needs of minority cannabis businesses and their communities. And their stated mission is to empower and support minority entrepreneurs and their communities by creating an equitable and sustainable cannabis industry. They have a website, which I've put up there. Not on the slide, but I do recall that here in New York, when the governor indicated that they were going to legalize this, there was a lot of press about, they also wanted to promote minority ownership of this now new legal business in marijuana. And this is, again, this is the real marijuana that's legal in New York and in other states. So this is a new business opportunity that needs to be promoted, not just to big corporations, but to all potential entrepreneurs. Next slide, please. The MCBA had a very interesting definition that I thought had a lot of thought behind it, so I put it up here. They say, what is social equity? And equity obviously is defined as being fair and impartial. And now they're trying to define it for the cannabis industry, which they say has 4 pillars. And I want to save time by not reading these off, but you can read what they are. They have equitable industry, equitable communities. Next slide. Equitable justice, that deals with criminal justice, arrests and imprisonment, and equitable access. So that is something that they have put together. I think it's very useful, and I commend the idea. I know that Lucien's slide, I think, does a lot more than I do now in explaining how marijuana and trademarks will affect social justice. I think the next slide is just our links. Yes, so when you get this, these should be live links, and you can get Senator Schumer's letter to his colleagues on why they should support his federal legislation, and the USPTO exam guide, which I've been discussing. Thank you very much, and turn it back to Tasha and bring in the next speaker.
Thanks so much, Bill. Thank you for that that conversation. I thought this was a timely topic with the pending legislation that's out there. So I'm glad you both could come today and talk about this. For the audience members, since we did start this panel a little late, we want to make sure that we get the full information in, and of course for full CLE credit for the timing. So we're going to go take up a little bit of the break and go through 225. Our next speaker is Laury Lucien, who is a wonderful speaker. I heard her at the USPTO, who came and spoke on this topic. So I'm not going to take up any more of your time. I'm going to let you take it away.
Hi, thank you so much for having me. I am super excited to be here, especially at the HBCU Tech Law Summit. I know that we have some of the D9 here. Any Greeks present? I am, you see the pink and green, representing my lovely sorors of Alpha Kappa Alpha Sorority Incorporated. So shout out to any sorors on this, participating in the summit today. Just to confirm, you will be switching the slides for me, correct? Ski-wee. Okay.
Yes,
So,
I will.
okay, thank you. Okay, so let me get started. So before I even introduce myself, everybody, all the sorors, all the sister sorors, before I even get started, I always want to begin by honoring the ancestors. And for me, I read a book about time that let me know that it's a little relative. So I consider myself a living ancestor. And as a living ancestor, it is my duty to ensure that I leave the world better for those coming after me. And in so doing, I also honor everyone who made it possible for me to be here today. And so that is why I placed that this slide there, and you can keep it there. And I will also give you a brief background as to who I am. My name is Laury Lucien. I am from Haiti. I moved to America when I was 15 years old during my senior year of high school in order to be a doctor, like every Haitian, right? So I went to UMass Amherst, majored in biology, and ended up doing cancer research, and then going into law school, and then ending up in healthcare law. I was involved in the regulations of various entities up and down the healthcare chain. And, with the hours of a big law firm, I was like, wow, I should really let somebody else enjoy this. So in the process of working at the firm, I began crafting my exit strategy. I mean, not to be Harriet, but she got out. Through cannabis. So I formed a company in California called Albert Einstein's. We're in stores there if you're ever in California. I also formed a consulting company in Massachusetts that helped people navigate the licensing process. I am I am one of the founders of Major Bloom, a company that has marijuana retail, manufacturing, and delivery. I am a founder of a brewery called 67 Degrees. And I like to call myself the Vice Queen, dipping my toes in bud and brews. Also, I will be launching my own women-owned company at the end of this month. So I'm super excited, doing a lot, and I'm grateful to be here. Next slide. So what my intention with this presentation is that I leave every single person on this call feeling empowered, energized, and elevated to pursue their own revolution, whatever that means for you. Okay. So but when it comes to this, I'm glad that Bill left us off with the social equity conversation, because now we're going to talk about why social equity even matters. Okay. And in order to do that, we have to understand a brief history of prohibition. And I hope you guys are ready to go down down history lane. You ready? You have no choice. You're here anyways. Okay. Sorry. All right. Next slide. So let's start. In America, between the 1600s and the 1890s, marijuana was freely legal. In fact, most people had tinctures with cannabis in their in their medicine cabinets. When I first learned this, I'm like, man, I wish I was there in the 1600s to the 1890s. And I was like, yo, slavery, let's take that back. But it was lit then. But then in around 1910, the consciousness of the American people began to change through social engineering with regard to cannabis. And what happened around 1910 that produced this beginning of the change with regard to the relationship to marijuana, where two things happened. In 1910, the doctors who were part of the American Medical Association were, I think the term is salty, that alternative medical practices were competing with these doctors. So what they did was they hired this doctor named Abraham Flexner, who believed in a German style of science in medicine, meaning that he wanted medicine to be the product of research and laboratory work. And then he also thought that practices like chiropractor, psychiatry, that they were quack. So at the time that he did he was preparing for his report, there were 155 medical schools in America, including these alternative medical schools. By the end, when the report was completed and implemented, there were 55 medical schools in America, which also contributes to the shortage of doctors that we have today. And also what they did was they said any medical school or school in general that taught these practices would lose accreditation. So this is what happened in 1910. And while this is going down, a Mexican revolution is happening. And Mexicans are immigrating into America and bringing with them their culture of consuming marijuana for recreational purposes or adult use purposes. As you know, the Puritans did not like having fun. So the cannabis was used for medicine and for food and for to make their clothes, but it wasn't used for the way that the Mexicans were using it. And so in an effort to criminalize the Mexicans, they started to criminalize marijuana, even changing the name of cannabis to marijuana to make it sound more Spanish. So the newspapers were producing a lot of content where they were, vilifying Mexicans, vilifying marijuana, saying things like marijuana will make you leave your husband and make you go with a black man. It's going to make you kill. It's all these things. So this is what started happening in 1910. And so by 1929, okay, the Great Depression happens. What happens when you ain't got no money? If you say you start blaming people for things that they can't control, that's it right there. So the people started looking around for somebody to blame for the Great Depression. And who did they blame? The Mexicans and the jazz musicians and marijuana. And so the public sentiment and resentment started to build against these particular groups. And at this time also, can you imagine not having any money and no access to alcohol? There's a whole entire prohibition going down at this time, y'all. And so by 1930, the Federal Bureau of Narcotics is instituted. So the person that they put to run this department, his name was Harry Anslinger. And I'm not somebody who hates on nepotism, because I can't hate on something that I don't have, because maybe if I had it, I would probably use it. But so the person who put him in this position was his wife's uncle, who was Andrew Mellon, the Secretary of the Department of Treasury. Now hold that thought, okay? Remember, Andrew Mellon put Harry Anslinger in this position, all right? So 1930 moves, Anslinger goes on a crusade. He wants to criminalize marijuana. Now, you guys remember constitutional law. They weren't going to use interstate commerce back then. And so he didn't know what to do. Should he dip his toes in the Tax Act? So he said, I'm going to try to get the states to do it. And he drafts the Uniform Narcotics Act, and he goes on a tour very much so like Beyonce would. Instead of spreading positivity and love, he was spreading hatred for marijuana and the desire to incarcerate people for the use of it. So many states did not adopt it. But by 1937, enough time had gone by where folks forgot what it was like to go to an herb doctor, right? The brainwashing had been complete. And it got to a point where there were no experts present when the Marijuana Tax Act was presented to defend the plant. Because at this point, alternative medicine is a quack, right? The German way is the only way. And so in 1937, the Marijuana Tax Act is instituted, which effectively created a ban on marijuana nationally. Next slide, please. Until this guy pulls up. I don't know, this may not be, psychedelic law is becoming a thing in America. So for those who are dipping their toes in that lake, Timothy Leary is an amazing person to look into. But back to the plan at hand. So Timothy Leary in 1966, what he does is he goes to Texas and he gets arrested. Why? Because in Texas, marijuana was illegal. And so compliance under federal law would have provided self-incriminating evidence. So he argued that the act violated his Fifth Amendment right against self-incrimination because abiding by the law would require him to register, right? And announce his intention to commit a crime. And you know what SCOTUS said? They said, bet, you're right. And on May 19, 1969, marijuana was again legal in America. Next slide, please. But Nixon said, not so fast, right? He said, you thought. Next slide, please. What he did was, he and his homies drafted the Controlled Substances Act. And what this act did was it created the 5 schedules that we have here. It included drugs in there based on medical values and potentials for addiction. So Schedule 1 was reserved for the most serious drugs, meaning they had a high potential for abuse. That's a cap when it comes to marijuana, right? Lack of any accepted medical use, that's a cap. Last cap, absence of any accepted use or benefits in medically supervised treatment. But get this, Nixon was slick. What he knew that there was evidence that marijuana did not produce the deleterious impacts he had claimed, but he was playing dumb. He said, well, I'm going to put marijuana as a Schedule 1 substance because there isn't enough scientific evidence to prove that it's not harmful. Next slide, please. So his administration put together the National Commission on Marijuana and Drug Abuse. What this commission did was they researched the impacts of marijuana and issued the first report. In their first report was included this following recommendation. It recommended that marijuana no longer be classified as a narcotic, since that definition associated marijuana with more addictive drugs like heroin. And it misled the public by exaggerating marijuana's harms. In other words, y'all were capping, take it out. Also, they recommended decriminalization. This was in 1970. So at this point, y'all are asking, why are my homies still in jail, right? This is why I get so tight. Anybody from New York, I'm sorry. I'm not even from New York. I don't know why I talk like this. Anyways, a second report was published and reaffirmed the findings. So twice. Next, please. He ignored it. He said, talk to the hands, because I'm not going to reason with you. And his administration kept marijuana as a Schedule 1 substance. Next slide, please. So what happened? Nixon gets dropped, right, as president. And Reagan takes over. Reagan then, even during Nixon's presidency, the American people had a medical approach to drug addiction. Even there was an option at times where through the NARA Act, if you were arrested for drugs, you had the option of getting treatment. That was over when Reagan took over. Next slide, please. What he wanted to do was destroy our communities. I mean, this is my own opinion too, but I mean, I can only read what was done. So when he arrived and became president, he and his wife were like, man, how do I ruin Black America? I got it. Let's go and do the Just Say No campaign so we can start incarcerating people for no real reason. So this is what they did. Nancy Reagan went and started the Just Say No campaign. So in 1985, in the minds of the American people, because this is where the war is fought, only 2 to 6% of Americans thought that drug abuse was the nation's #1 problem. But after this tour in 1989, that number jumped to 64%. Next slide, please. Leading the way to this, before that. Leading the way to the Anti-Drug Abuse Act of 1986, right? So what they did was they budgeted $1.7 billion to the drug war. They imposed mandatory minimum sentences and instituted the 100-to-1 disparity between powder and crack cocaine. For some of us, let's do some math real quick. If I have 500 grams of powder cocaine and 5 grams of crack cocaine, we do in the same time. That's a shame. I also got bars. Next slide, please. But you can... Next. We're gonna skip through these. Yep, next. You're like, why are they in there? I want y'all to have it. Okay, now, Reagan's out of office. Y'all homie, George W. Bush takes power. Did he slow this down? If you said no, you're right. He continued to fight aggressively. In fact, they enacted the Anti-Drug Abuse Act of 1988 that created the Office of National Drug Control Policy. And the strategy for this office when it came to illegal drugs was arresting more people in targeted communities. And they said, this quote, effective street level enforcement means dramatically increasing the number of drug offenders arrested. Now, how is that helping? I don't know. No one asked me. Next, please. And then, this one gets me even like more fired up just because of this picture. He had the nerves to pull up on Arsenio Hall. But anyways, this man, what he did was he signed the Violent Crime Control and Law Enforcement Act of 1994, the crime bill, into law, which contained 3 strikes, mandatory life imprisonment. He had 100,000 new police officers, $9.7 billion for funding for prisons, $6.1 billion in funding for prevention programs designed by police officers, $2.6 billion of funding for the FBI, DEA, INS, the attorneys, Justice Department components, federal courts, and Treasury Department. This dude arrested more Blacks imprisoned more Blacks than ever in American history. Drug arrests rose by 46%. This is why he makes my blood boil. And he should make yours too. Next. All right, now that we're hot, you guys mad? Good, fire is great. It extinguishes ignorance. Let's go. And it incites action. So I'm not gonna spend too much time on the tools used to sustain the war on drugs, but these are there are 3 mechanisms that the government uses to sustain the war on drugs. Next. So I don't know if you guys have heard of the broken window model, but the central premise of this model is that the appearance of disorder begets actual disorder. So if I can address the minor indicators of neighborhood decay and disorder, and I can crack down on petty offenses, and I will reduce serious crime attracted and fueled by such disorder. So in effect, the broken window model, what it did was it reframed visual cues that were traditionally associated with economic and social disadvantages as signs of crime and disorder. Next. So an example of this would be stop and frisk in New York. So what they did was they implemented order maintenance policing strategies that focused on the enforcement of low level and quality of life offenses. So in 1991, the NYPD made 44,000 stops. By 2010, they had made over 601,000 stops. And in 2011, they had made, again, over 685,000 stops, and 88% of those people were innocent. Meanwhile, 87% of the people stopped were Black or Latino, even though the white people were twice as likely to have weapons on them. So the purpose for the stop and frisk didn't make no sense. Next thing that they used was CompStat. Meanwhile, I said I wasn't gonna take too much time. This is the only time I'll lie to you. Anyways, CompStat is a technological and management system. It combines police department, geographic information with police accountability. So the purpose of this program was to enable police departments to identify and address specific crimes quickly and efficiently. What it does is it monitors crime patterns by location, resulting in deployment of police resources to specific areas in neighborhood. So the accountability system also required precinct commanders to account for rates of crimes at twice weekly crime control strategy meetings. I call them lock 'em up meetings. Yeah. Let's see, next. One of the problems with with this CompStat was using arrest numbers as performance metrics for success. Next. So the issue is like CompStat by itself isn't a problem. It's when CompStat is combined with the broken window model. When used by police departments employing a form of broken windows, what it does is it encourages the aggressive and frequent enforcement of low-level offenses in minor infractions by calling heavy police resources to areas designated as crime hotspots. Y'all following? All right, I think I got 8 minutes. Next. The next part is the Justice Assistance Grant Program. So it was established in 1988. What it does is it provides states and local units of government with funding to improve functioning of criminal justice system. Next. So you can get this funding for 7 general programs like law enforcement, prosecution, crime prevention, corrections, and community, all of this. But of the $500 million spent every year on average in jurisdictions across the country, over 50% is used to fund law enforcement activities. Next. Law enforcement agencies have to project their goals and objectives in order to qualify for this grant. And along with reporting the number of investigations and prosecutions, law enforcement are required to report the total number of arrests as part of their performance measures. Problematic. So next, let's see. Okay, you can go back to the next slide. The previous slide. So the issue with this is that because the police departments are incentivized to by number of arrests, they are then incentivized to get people for low-level offenses like drugs or prostitution, instead of focusing on getting well-trained individuals to go after more complicated crimes like child trafficking and white-collar crimes, etc. Does that make sense? Okay, next. Thank you. So now I'm going to leave this history and we're getting into modern times. In modern times, we're seeing a lot of states decriminalize and legalize cannabis within their own jurisdictions. And the process that they usually take is this. And this is what happened in Massachusetts. First, in 2008, we the people decided that we no longer wanted to go to prison for having an ounce or more or less of marijuana. So we decriminalized it. And then in 2012, we the people got together again and said, we no longer want our patients to not have access to clean and reliable medicine. So we legalized medical marijuana. In 2016, we realized that despite the fact that marijuana is decriminalized and medical marijuana was accessible, Blacks were still being arrested at a rate of 4 times as white people, despite the fact that both groups are using cannabis at the same rate. So we also, we wanted to give the people access to clean, reliable marijuana, and we the people legalized in 2016. Next. So in conjunction with legalization, one of the things that Massachusetts tried to do was make amends for the wrongs that they had done in enforcing the marijuana laws. Their solution to this was creating these equity programs. They gave priority to 2 groups, economic empowerment and medical treatment centers. They also created this program called social equity for those who have marijuana charges or live in one of 29 neighborhoods that they've designated as being most harmed by the war on drugs. They also provided a 36-month exclusivity for social consumption and delivery licenses. Next. So with, you can keep going. With my 5 minutes, keep going. I want to get into so we'll stop here. Medical marijuana, in the difference between medical marijuana license and adult use is that medical marijuana requires you to be vertically integrated. So you have 1 license and it allows you to do everything from seed to sale, but you have 2 locations out of which you can do that. And you have a maximum of 3 of those. Adult use, they separated those licenses into 11 different licenses. And you can actually be a cultivator, manufacturer, cooperative, micro business, retailer. And that's because it makes a better, more robust industry. Next. So we can keep going. Next. So right now we have over 37 states in the adult use and with medical programs. And next. And over 17 states with adult use programs. Next. Keep going. So I have like 4 minutes, but we'll stop at this one. No, we can go to the next one. Yeah. So I just wanted to highlight that legalization has a real impact on arrest rates. So if you can see in states that were fully illegal before 2018, Black people, the likelihood of that a Black person will be arrested in that state actually increased to 3.41 times. So it's as if legalizing across America is getting these states mad. But then if you can look in 28, those that decriminalized, it actually went down to 3.02 from 3.85. And in states where it was legal before 2018, it actually dropped even further. So we're seeing some real impacts on arrest rates when we have legalization in some form of decriminalization in states. Next. Okay, so if you guys were contemplating, should I get into the cannabis industry? If you like money, perhaps. Because Massachusetts, as of September 1st, 2021, has amassed $2 billion in gross sales. Next. And this is where I want to get into the franchising and franchising with respect to licensed businesses in Massachusetts, but this will also apply to any state where they have limits on licenses. So in Massachusetts, you can only own a person or entity that has direct or indirect control can only own 3 licenses in a particular class. And I showed you those 11 classes. And there are some exceptions to those. But in the medical, you can have 3 medical licenses, though they're vertically integrated. But when it comes to franchising laws, oftentimes contracts exert a lot of control through the terms, and that can cause a company to violate the 3 license limit. And let me explain that to you by explaining to you what a person or entity having direct control actually is. And I like to call them PEDICs. Next slide. So yeah, so like Cardi B's asking, what's a PEDIC? Next. So you can be a PEDIC through direct control by being an owner with 10% or more equity, with voting rights, 10% or more, or the right to veto significant events. Here you can have a relevant managerial, operational, and this is where you get into issues with franchises, or financial interest in licensee that enables the exercise of significant influence over a business's management, operations, or finances. Also, you can get direct control through contractual or other authority by having the right to make major operational, strategic planning decisions, capital decisions regarding capital allocations, acquisitions, and divestments. Also, if you're able to appoint 50% or more of the directors, appoint or remove corporate level officers, make major marketing or operational decisions, and execute significant contracts, or even earn 10% or more of the profits, that will render you a PEDIC through direct control. Next. This is the indirect control is my favorite. First, the first way is you're a person with controlling interest in an indirect holding or parent company. The other one is you're the CEO or executive director of those companies. Lastly, the most clarifying one is a person or entity in a position to indirectly control the decision-making of licensee. That is so broad that almost anybody can be a PEDIC. So when drafting franchise agreements, you have to be very mindful if your client wants to own more than 3 franchises in this state. Next. So the Cannabis Control Commission disapproves of franchises in general due to the ownership and control restrictions. Usually what multi-state operators will do, they'll have multiple brands to avoid the 3 license maximum cap, or operate both medical and adult use businesses. Next. Do we have more time for advertising? I can stop here and take questions.
Hi, yeah, I think we're gonna have to stop and move on to the next panel, but I do want to thank you for this excellent presentation. As Laury mentioned, there's a lot more in her slides that you guys can take a look at. The slides are available on the website for downloading, and hopefully we'll be able to connect and do more together so you can we can find, more audiences to provide this information, because this is just a dynamic history that I think we need to know and need to know more of in this blooming industry. So thank you so much.
Absolutely. Thank you so much for the opportunity.
And so next we will be moving to our dual track panel sessions. Session A will be hosted in this room. It's Hot Topics in Post-Corona In-House Practice.